Ja, jeg skal ta for meg en del spesielle problemstillinger.
I'm going to focus on a few particular issues. I apologize for the sound of my voice. I have a cold, but I hope you'll be okay, says the speaker. I'd like to begin by telling you a little bit about the thinking in relation to the conventions. When this system with ECLs were first brought up, there are some perspectives that could be well worth reflecting upon and looking at what's happened since. The first agreements dealt with broadcasting, but they are really quite different to what we're talking about nowadays. These were compulsory licenses, and it was stipulated what the broadcasting company may do, what it may do, the broadcasting company. And there are also provisions on the copyright holders. Well, they should receive compensation paid by the broadcasting company. So a forced license by way of an agreement, but it didn't stipulate anything further really than that. And the basis for this was that the rights holder was the weaker party, and they wanted to improve their negotiating power. Better than what was provided if you were to deal with it on an individual basis. And then we get to the 1970s and 80s with the introduction of the current agreement type for licenses. In educational operations and the photocopying, you probably know the Berne, you're familiar with the Berne Convention with the three-step test in 9.2, and we'll find it in TRIPS and the WIPO copyright treaty, which is applicable also to other things than photocopying. What was the problem and what was the solution? Well, they wanted to cover the needs for educational and teaching purposes, and that differed from one institution to another, compulsory schools as opposed to university, for example, and adaptations over time, and a new type of licensing agreement where you introduce other areas. And you would instead adopt agreements with organizations, which in a particular area would be the representative of the rights holder and the copyright holders nationally, what was permitted and which remuneration would be paid. And it would also cover rights holders outside of this. So it was a collective agreement signed voluntarily, where you were more familiar with the particular conditions, and you could therefore make the assessments required in the three-step test so that it wouldn't negatively impact or be to the detriment of regular use, nor impact adversely the rights holder. And the limitation to certain special cases, of course, in the areas stated by legislation will be more closely defined when you come into what is permitted in this particular agreement. And not least, how is usage going to be made possible? And in this manner, in the light of all this, you can see the management organization as the managing body. Through the operational agreement praxis, they operate this. And they would be the representative of the rights holders. So far, I think it worked fairly well in relation to the Berne Convention, but one reason for doubt was how remuneration was handled. Individual payments wasn't terribly practical. For example, the payment, you wanted a collective collection, and there was statistics that was required. So in the interest of both parties, in fact, the solution was to say that the agreement or the organization which received the remuneration would decide on the collection and distribution, and it also applies to those on the outside, those right holders. And they have a requirement to be dealt with on par with, on an equal footing with the represented rights holders. And at least that was complied with the equal treatment requirement as stated in the Berne Convention. The national treatment, but was it good enough considering it had to pass the three-step test? And that we didn't have the very clear possibility of receiving remuneration. And what can be permitted free of charge within the scope of the three-step test. So you had to use this collectively supporting scheme of stipends, etc. And the solution was to give outsiders the right to require individual remuneration. But in the Nordic countries, the opinions differed as to whether this was actually a solution to that problem. In Denmark, Finland and Sweden, the answer was yes, they introduced such copyright provisions in the early 1980s, but in Norway they were less sure. And that was perhaps also linked to the situation in Norway, of course. In the law from 1979 on photocopying, there was a restriction first to only apply to Norwegian works, considering the Berne Convention, in fact. There were some question marks as to whether this was feasible. Those outside need to be familiar with the provisions. The stipend scheme needed to be applied correctly, and the rights holders, the non-Norwegian rights holders, might not have been familiar with the provisions, and they also needed to know that they had a right to request an individual compensation. 1985, however, the provisions were extended to foreign works of art, but it was only those who had, where we had the international component. The Norwegian ones were not entitled to request individual compensation. And it's also worth mentioning that in this context, Kopinor, the Norwegian managing organization in this area, had signed agreement with sister organizations in many other countries, so that we were entitled to collectively collect remuneration, and that was then passed on to international or to other management organizations. And the law had to be designed in such a way that it also applied to non-Norwegian works. But then there was also a question of whether or not this was required or desired to have the right to issue a reservation. Sweden concluded that this was required, but Denmark and Finland did not come to the same conclusion. They could leave it to the agreements, to the licenses, but in Norway, I think the atmosphere was that it wasn't desirable and it might not have been necessary either. In this particular field, there was talk of photocopying already published books, etc., that had already been published, and that the opt-out right was there. And then the requirement for representativity. There was a requirement that it should be national organization representative, national creators and producers. They needed to represent a significant number of them, or a significant part. So you had to look into the reasonability when it came to signing these agreements. And Kopinor, as I mentioned, had signed agreements with sister organizations, and those agreements also covered a provision where they gave and received representation rights, even if national legislation didn't create a need for it. So representativity was there, and this was practiced, and in that way they preempted the adaptation, which I insisted on earlier. And here it was not possible to have a requirement for it to be national producers or creators or artists. You had to represent a significant part of those in a particular country. This has not really been well, the idea was a non-discrimination perspective, and with the EU you might also have the ulterior motives of competitiveness, not least. But this, of course, entails a shift, a change from looking at the central point of representativity being a knowledge and insight of the markets where this is going to take place, and to base evaluation on that. And that was the idea of having these the national point of the copyright holders as an argument. So if you're moving the representativity from the qualitative perspective, going in the directive of the quantitative directive, what impact is this going to have? Well, we've had a great deal of controversy in Norway in our discussions on this point. It could also be linked to the way ECL provisions are perceived. They're more moving in the direction of perceiving this as a management system, removing it entirely from the three-step idea. This is entirely contractually based management. And removing the nationality requirement is probably a necessary precondition to move ECLs across borders. But I won't enter into that point now. Oops, where am I now in my presentation, says the speaker. Okay. There we go. And gradually we've seen more ECL provisions, 18 in the InfoSoc directive, for example. Legislators have shown less of an interest in the three-step test. And now, with the general license, we have a limitation to certain special cases. And in reality, this has been transferred to the agreement, with individual declarations being in some of the reasons to the law. They've said that the Norwegian Minister of Culture actually said in the government bill that it would be unpractical or impossible. There have been many counter-arguments, in particular from distributors and producers, of course. And an agreement license is not to be used where the conditions are the basis for declaration that can be done on an individual basis with the rights holders or their organizations. In Denmark, they say that it's not practically possible to have some of these agreements in Sweden. In the legal previews, they've said that it's not difficult, that it's difficult in advance to declare exactly what's possible, and that it might be necessary to declare in a particular case. And they're clarifying that an ECL, a license, is required for the entire scope of usage, so that it's not possible to identify with limited areas of use where there is no need for a complete declaration of rights. The scope is too broad and may need to be limited further in order for this to have the full impact of an ECL. So how is this then going to work? Can you set limits in some other manner with stricter criteria? Because when it comes to the delimitation of the scope, you might see that there is in fact some elements of link, at least in terms of the basis we've set for using these licenses. But is it a final limit? It's a much more solid closing in, and perhaps a stricter limitation than if you go into the criteria of the test. And the criteria is meant to be overarching, of course. Let's see. Because there's a difference between having this criterion going into analysis and asking if this is negatively impacting normal use, what we're doing here. And does it in any other way limit the possibilities of the rights holder and their interest in putting their work to use? And it's not just individual use. Well, individual use is one thing, but then there's also the detriment as per the three-step test. So some of the nuances may be lost. And is that going to also have an impact on the special case scenarios if we start thinking along those lines? Because, of course, it's not the case that we have been so sharp in the way we've limited the use of ECLs as if we were to say that these criteria, when we're talking ECLs, would be really taken word for word.
Og da får man jo tilsynelatende et paradoks.
So you end up with a paradox that the framework for the license as a pure management order sets stricter requirements than provisions that would have been considered as an impact of the agreement element. Or rather, is it the fact that you're not using the three-step test? It sets the basis for us having to pay close attention to this. So there's a shift in perspective when it comes to the individual as opposed to collective management. And if we've translated some of we had when we started with licenses and benefits of collective management and what it can give the rights holders who might be in a difficult situation otherwise in their dealings with another dominant party, which of course used to be the case when dealing with, say, a broadcasting company. So the perspective with these ECLs might no longer be there in the sense that it's providing support. But if we have a collective management and you need access, what about access to the full repertoire? Major players will come and say, no, I have agreements, I have all the rights, you don't have to worry, I'll take care of all this. And they cover parts of the market, they won't cover absolutely everything. But this is where you come into cultural policy aspects of collective rights management. And collectives which can be impacted in these general provisions using licenses for broadcasting. And then you might ask yourself also whether or not this isn't a little bit contradictory. You have the ECLs, the collective licenses. They give way for individual permissions or agreements, so that if you have a subscription license which says that I'm permitted to do this and this, well then that is what is applicable. And both in a negative and in a positive manner, and you cannot use the contract collective license that you've said in a subscription agreement that you can't do. You have to stick to the agreement signed for the subscription, and you can't deviate from it. A non-exclusivity, which we have here, and if a management organization is based on exclusive proxies, and that's not very common in all areas, photography, for example. That's a point to consider. And then you have the question of individual prohibitions. If there's an opt-out, that could be part of an agreement which is in an ECL, and that links to the problem here. If the agreement in itself has an opt-out, well, clearly the opt-out is there both for the ones who have the proxy in the organization and those who are outside. In the area of books, the problem is there.
Og da jeg kommet sånn at jeg tror jeg skal bare avslutte med den siste sliden her.
And now I'm going to conclude with my final slide, and I'll remind you that the license, the ECL, is not a limitation in access to taking action which is permitted according to law. I think we've actually even had a case, a legal case in Norway in this respect, where a teaching organization had an agreement, and it is to also be used when you're photocopying within that institution for private use, so that the personal professional use concept has been a problem, and they tried to catch that in the collective license so that you would get away from some of the matters of interpretation of the scope in terms of photocopying for private use. And that's a very topical issue, of course. But here it was ruled in a case between the municipalities and Kopinor, and it's relevant to in relation to schools. That in the legal previews that was mentioned, but it wasn't considered. It was disregarded. But you still have the question whether or not there was unused potential here for compensation when photocopying for private use, in quite an elegant manner, in fact. They disregarded that possibility. Thank you.